Good afternoon. First of all, I'd like to say that I'm so glad to be here today as AACE Brazil's representative, joining Giovanni and Jaime, both from DRBF, to discuss about this important matter, which is dispute board. In my opinion, dispute board is more than attendance. It's one of the most important skills to prevent conflicts. Today, I'll be the host of this event, and I'm sure that at the end of this webinar, I've learned much more than I ever know about disputes. Sorry. In this webinar today, we'll be speaking about the DAB procedure Rule H. The employer and the contractor empower the DAB. We will be speaking about Rule H, letter A to letter H. Before we start our webinar, I'd like to introduce myself, and after that, I'll ask Giovanni and Jaime to introduce themselves. So my name is Ilma Trindade. I was recently elected president of AACE Brazil section. I'm partner of 𝐂𝐀𝐂𝐄 𝐒𝐿, expert in arbitration, dispute boards member. I've been working in oil and gas, infrastructure and energy contracts and construction for over 30 years. Also, I'm a project manager and a specialist in contractual administration. Besides of that, I'm a member of DRBF. Now, Giovanni and then Jaime, please introduce yourselves.
Thank you, Ilma. Good day to everyone. It's late afternoon where I am speaking from, which is back in Europe. My name is Giovanni Di Folco. I am a duly qualified civil engineer and legal practitioner, and I'm an adjudicator, an international arbitrator, and an expert witness in delay and quantum, and I act as counsel for clients as well. Thank you.
Jaime, please.
My name is Jaime Gray. I'm based in Lima. I'm a founder partner of NPG Abogados, based in Lima, of course. And I'm glad to say that I am the first president of Region 4 of the DRBF, and that's such an honor. And I would like to say that being the president means to be the first server. I'm at your service. That's very important to be said. Thank you, Ilma.
Okay, thank you very much. Now I'll be asking you some questions about the DAB procedure Rule H that we prepared previously. So I read because the questions are too long and it's necessary to read. So about the Rule H, letter A, the Rule H-A states that the DAB has the power to establish the procedure to be applied in deciding a dispute. Regarding this point, are you of the view that the DAB could issue to the parties a set of proposed made additional procedure rules for the referral of a dispute to the dispute board? I'd like to know what your opinion, and please, Giovanni, could you start give us your opinion, and then Jaime.
Thank you, Ilma. In all my boards where I sit either as a chairman or a sole adjudicator, whether it is a standing DAB where the dispute board has been appointed from the very beginning of the project and visits the site regularly, or it is an ad hoc board which comes after a dispute. I always carry out, for the benefit of the parties, an initial workshop explaining the workings of the dispute board and explain them obviously which is the role as far as site visits are concerned, as well as the dispute avoidance role of the dispute board. And then I explained them in the event that there should not be an agreement on an issues and a party wishes to refer a dispute. I will provide them how it works. And then at the end of the workshop, I hand them a guidance note. And I ask them if they will accept to act in accordance with the guidance note, which is up to them. And this gives a bit of a more structured approach than leave it too loose in the hands of the parties, and makes the life of the dispute board easier as well to deal with the pleadings that the party may issue in a dispute, and obviously educates them ahead of time on what is expected from them as far as the timing and arriving at a hearing, how normally they should behave, so that they get a preview of what could be. And this is normally how I handle it. Jaime?
Okay,
Yeah,
Jaime.
I think that, of course, I agree with Giovanni's point of view. And I think that it is good to have these two approaches, both possibilities available to the DAB and the parties. Regarding the meeting that Giovanni has mentioned, I think that that's a very, very important meeting, because you also know what are the expectations of the party, and you educate them and you learn from them. So it is good to have these two possibilities. Why? Because in some cases, it makes perfect sense to issue specific procedural rules for answering a summation or examining witnesses, etc. Okay, but that very much depends on the nature of the dispute. For example, a simple interpretation of the contract, in my view, and that's my opinion, will not need special rules, while a complex dispute having multiple technical issues to resolve and witnesses and experts to examine may need more rules. Which approach to follow will also depend on the sophistication of the parties and their representatives, as well on the good or bad relationship they have. So I think that it is good to have these options, and as Giovanni has mentioned, give importance to this first meeting in which you really take the temperature, so to speak, of the parties, their expectations, etc. Thank you.
Very good. So regarding the Rule HB, it states that the DAB can decide upon the DAB's own jurisdiction and as to the scope of any dispute referred to it. Could, in your opinion, this means that the DAB can decide as to whether it can properly consider the merits of a dispute and also as to the limit of the issues that it can decide? Jaime, please give your opinion.
Thank you. Thank you. Dear Ilma, I should give a note of warning here, because I will say something which could sound a little bit legalistic, okay? That's a note of warning. Why? Because, you know, in our Latin American region, okay, we need to take into consideration that we cannot really use the concept of jurisdiction as understood in civil law. Why? Because in civil law countries, only judges really apply the concept of jurisdiction. And in some countries, not all, also arbitration. But let's remember that dispute boards are a contractual animal. Dispute boards are contractual creatures, and panels which cannot apply the concept of jurisdiction as understood in civil law. That said, these rules should be understood as one which allows dispute boards to consider if they have the powers to specifically resolve the type of dispute which has been presented to the dispute board. This is very important in our countries, as some public law, administrative law may apply. And sometimes these rules limit the power granted by the power to the dispute board. In my view, these rules gives the dispute board the power to define the scope of the dispute, and this is very important. Since sometimes, not always, parties present submissions in which the scope of the dispute itself is not clear or present gray area. What's your view on this, Giovanni?
Thanks, Jaime. You made a very important point that the workings of the dispute boards are a creature of the contract. You know, they are not regulated by law. They do not have the force of law, the DAB decisions. Otherwise, they could be enforceable immediately in a court of first instance. Because it's a creature of contract, and the parties have entered into a tripartite agreement with the dispute board, which is separate from the main contract. That it's a private agreement between the parties and the dispute board, that the dispute board has certain powers, and at his discretion he can use them, and the parties have empowered by entering into a tripartite contract, and they will have to abide, because if they don't, they will be in breach of contract. However, it is another very good point that Jaime made is on the definition of jurisdiction. What is meant here is that the DAB should be experienced enough to understand at the very beginning whether a dispute has really occurred and is capable under subclause 20.4 to be referred to the DAB. Because if there is no dispute, the parties are still waiting for an engineer determination, or you know, they are still discussing, and one party submits a referral, the DAB has the duty to say, I will not be in a position to give you a decision on this matter because a dispute is not crystallized yet. So I will not have that power to which you bestowed on me. And I will be, in a way, out of my jurisdiction to do that, and my decision can be challenged. You don't want that. So the work of the DAB is actually to guide the parties, especially in the first meeting, to make them understand that there is a certain level of procedure that they need to abide in order for the DAB to be within the realm of what those powers are. For instance, I say to the party, if you do submit a referral, make sure that on the first page it says, referral submitted under subclause 20.4 of the contract, because if it is not under 20.4 of our contract, I cannot give you a decision because I'm not empowered to do so. Obviously, there is also another issue, the limits of what the dispute board can deal. If there is a matter that obviously has not been properly pleaded by the party, the dispute board has no powers under the tripartite agreement to issue any opinion or to discuss about the matter, because it will be out of his remit. So this is basically the way I see it.
Okay, very good explanations. Jaime, do you want to?
Before we go to the next question, let me please back up what Giovanni has said, okay? And share a war story. You know, in one occasion, I had to have an informal conversation with the parties, allowing them to first, you know, complete what is required in accordance with the contract, okay? And that's it. Sometimes, for example, to issue, you know, an engineer determination. Sometimes, you know, they think that they have a dispute and they don't have a proper dispute. So it is important also to have guidance and have conversations with the party in order to avoid having immature disputes submitted to the dispute board. That's it.
Very good. So the next one, The Rule HC states that the DAB can conduct any reading as he thinks fit, not being bound by any rules or procedures other than those contained in the contract and these rules. Would you agree that the DAB has absolute flexibility to hold hearings in a manner that best suits the circumstance of the dispute between the parties? Giovanni, please.
Thanks, Ilma. The question of the hearing obviously is handled depending on what the parties and the dispute board have agreed. If it's a simple matter, they could agree that it is a document only. So an interpretation or contract. So obviously there wouldn't be the need for a hearing. And if the parties do not ask for one, either party for that matter, then obviously the DAB should have a certain care of time and cost efficiency of the dispute. The way that it handles it will reduce the cost of the parties. A hearing, however, even if the parties do not ask for one, sometimes the DAB can actually tell the parties that there will be a hearing, because even if the DAB decides on his own procedure and he may have requested answers to some of his questions and queries. However, on account of the time, it's 84 days at the end of the day, and if it's not extended, it's very limited time. They may submit, answers that do not really help much the dispute board. So the hearing requested by the DAB and actually will help in such cases for the DAB to put the questions again to the parties and in person ask them, what they meant for this or that and what evidence they used, and to take the DAB to the pleadings to show him where it is, because you must understand sometimes these disputes are quite complex, and we receive thousands of pages and analysis, technical delay, quantum. We get hit with some very complicated issues, and obviously by having a day or two of hearing, basically the DAB allows the party to take the DAB by the hand to the evidence, in order that the DAB understands and can give obviously a well-reasoned DAB decision. Jaime?
Excellent response, Giovanni. I will just supplement what you said by saying that I have an issue with the words absolute flexibility. Okay, I think that the boards have a very ample flexibility to conduct hearings, but I would not say absolute flexibility. Why? Because there are some overarching principles that should always be applied, such as allowing the parties to be heard, granting equal opportunities to the parties to present their case, etc. However, this not means that the hearings in the dispute board process are similar to hearings which are part of arbitral procedures. These dispute board hearings will always be more flexible and more focused on technical and factual issues. Flexibility is welcome, and correctly used certainly will help the parties and the dispute board to resolve the issue. That's what I would like to say in addition to what you say there, Giovanni.
Good point, Jaime.
Yes, well pointed. About the next one, when reading Rule HD, which states that the DAB can take the initiative in ascertaining the facts and matters required for a decision, is your interpretation and perhaps opinion that the DAB, to be able to make an informed and impartial decision, has the power to act independently in finding out all of the necessary information needed to make a decision? Please, Jaime.
Thank you, Ilma. Sorry. I think that this rule helps the dispute board to lead the process, okay? And this is, linked to what Giovanni mentioned before.
Yes.
When evaluating the facts and matters as the dispute board thinks fit, and not necessarily following what the parties suggest, should apply with a certain fact and matter. Also, this important rule helps dispute board for not employing more arbitration types rules of conduct when evaluating facts and matters. Sometimes you receive, requests from the parties to practically follow, this arbitration type rules of conduct, and I think that's a waste of time, respectfully. However, this does not necessarily mean that the dispute board will act in an absolutely independent way. But trust me when I say that this leadership from the dispute board will be helpful for the parties and the dispute board process. I couldn't agree more with Giovanni when he mentioned this. Many times I have seen that the parties simply waste time on unnecessary questions and procedures. This is why it makes sense to grant dispute board deep power. However, in my view, it's a matter of leadership. And that means that sometimes you could be informal and sometimes more inquisitorial in some other occasions. What do you think, Giovanni?
Well, you hit the nail on top of the head. The role of the DAB is also that of a father figure, the honest family man that guides the parties. We're not judges, we're not arbitrators. We are facilitators at the end of the day. Yes, we give a DAB decision that is binding. It could become finally binding and will have obviously a certain strength on the next phases of dispute resolution. The way I read this Rule 8D is that basically the power, the power that has been bestowed on the DAB by the parties is an inquisitorial one, which allows the DAB to be inquisitive and ask questions and request additional information, guide the parties, perhaps. The merits could be split from the quantum and explain to the parties that if they will allow by agreement the dispute board to deal first with the merits of the dispute and then on the separate phase, basically bifurcating the procedure by agreement, dealing with the quantum, okay, it will obviously resolve, because if the dispute board decides that there is no merits, then there will be no need to go and look at the quantum, and they will save time and money. Because if the DAB has to look at a claim for extension of time, and then is to look at the quantum, all in one dispute, and then he realizes at a certain point that some of the matters are time barred, and he believes that there is no entitlement. He has wasted a lot of time and has made the parties lose time and money. So this rule basically gives that initiative to the dispute board to talk to the party and guide them to saying, wouldn't it be better, please, discuss it between yourselves, and then come back to me to handle this, in a more structured manner by dividing the issues, in order that, if I disagree on one party, there will be no need to go further and spend 10 days on looking at thousands of invoices and the way it's been calculated and so forth and so on. And at the same time, allows the dispute board to say, I would like to see these documents. For instance, can I see the engineers' reports to the employers, which obviously the contractor is not privy, and it has that inquisitorial power. So it's a very good point, this 8D, in my view.
Yes, it's a very important point. So very good. When the next one, when analyzing Rule 8E, which states that the DAB can make use of its own specialist knowledge, if any, would be reasonable to deduce that the DAB may draw on its own expertise in a particular field to supplement its understanding of the technical, contractual, and legal issues in the dispute, and that in doing so, the DAB is empowered to exercise its own discretion and judgment to reach a decision that it believes is fair and just. Please, Giovanni, what's your opinion about it?
Although this rule has been written in a very short sentence, make use of its own specialist knowledge, if any. Obviously, there is quite a lot behind the simple phrase. Dispute boards are formed by professionals that may have a technical background, legal background, accounting background, and obviously when they sign the dispute board agreement, it is clearly stated in there that they require the dispute board to make use of his own expertise, because that's the reason why it has been chosen. However, this has to be looked a bit more deeply, I believe, because there is no dispute board that has all the skills to deal with any aspects of a dispute. That don't exist, these adjudicators. There will be Superman from another planet. We are human beings with many years of experience. We have a certain training, but we do not have, for instance, I have a civil engineering background. I can deal with a matter of structural engineering, but I cannot deal with a matter of geotechnical engineering because it's not my specialization. So obviously, I will make use of my knowledge, for which I have guaranteed that I will do so by signing the tripartite dispute board agreement. But this will also allow me to tell to the parties that I do not have this particular aspect of expertise. And if you would like me to give a very well-reasoned and balanced dispute, I would need the help of an expert. And if the parties would agree, I will propose a number of experts and their rates. And if parties do not have any particular objection to a specific expert, I will obviously pay the expert, and then I will charge those costs to the parties. But that will allow me to have a very well-balanced approach to when I will give a reasoned decision, and not just stretch my knowledge to an aspect that I know I did not have experience in it. And I cannot have experience in every aspect of it. The fact that someone is a lawyer doesn't mean that he can deal on any matters of law. He specializes in a particular aspect of law, and the same an engineer, the same a quantity surveyor. So this is where I read it.
Yes, okay. Please, Jaime.
I couldn't agree more with Giovanni. You know, you are a member of a dispute board. You're not Superman, and you are not an independent expert, and you should not act as such. You should act as a dispute board member. That's very, very important. And so regarding this, I would like to supplement what Giovanni has said with just two ideas. The first is that, yes, okay, to understand the technical, contractual, and legal issues, you could use your own specialist knowledge. But it's a matter of just understanding, not acting as an independent expert or a specialist that you are not. Okay, if you remember again, that's very important. That comes first in your mind, that comes second in your mind. And yes, your knowledge is good to understand the technical issues, the legal issues, but you cannot act as an independent expert. And also, I would like to say that reaching a decision is a complex process, and that the dispute board should not use this specialist knowledge. Should use this specialist knowledge with the utmost care. Okay, you cannot simply say, I don't care about the evidence that you presented, of what the expert said because I am the specialist. Okay, you should not rely only on your own specialist knowledge. When making decisions, all matters, everything, evidence, etc., should be jointly evaluated and globally taken into consideration. And that's very important again. So yes, this is an excellent rule, but this power should be exercised with due care. That's what I wanted to say. Thank you.
It's a very good point, Jaime. I can give you an example. Let's say that you are appointed as part of a 3-member board in a dispute in Chile on a FDBF yellow book, for instance, design and build, and obviously you are one of the DRBF members is a civil engineer who had experience in structural engineering, so designing of building and as well as of structures, and there is an issue of dispute regarding the seismic analysis that has been prepared by the contractor as designer. And then obviously the engineers disagrees on a point and the employer takes the view of the engineer. And even after they have had some various discussions and they brought the experts from the party, they do not get to agree on that. And they go to the DRBF and they refer the matter to the DRBF. Or they ask the DRBF for an informal opinion on the matter. You know, the fact that you are a civil engineer specialized in structural calculation, that doesn't mean that you have the experience or how seismic analysis is carried out in Chile if you studied in England or in Italy, because you have different parameters and there are different risk assessment that you have to take in consideration that only a local expert that is obliged to apply a building code or certain standards of the country does have the experience that he has proven it, because we're dealing with seismic analysis. This is life and death. You make a mistake and then under a minor earthquake, the structure will fall down and will kill people. So this is a serious matter, and we should never have, you know, the understanding that we have to prove that we can deal with everything. Like another issue. Parties believes that because someone is a DRBF, he is a delay expert or is a quantum expert. Absolutely none. There's very few of us that can deal with a delay analysis because it's a highly specialized trade. So there has to be proper due care on how we handle this power. And we have to be honest with ourselves first. We have a major responsibility to carry when we are trusted as dispute board member, and the point that Jaime made is really a very important one. Thank you.
Yeah, it's a very important question. So the next one, under an in-depth analysis of Rule HF, which states that the DRBF has the power to decide upon the payment of financing charge in accordance with the contract. What's your opinion about it, please, Jaime?
Thank you, Ilma. Honestly, I think that this is one of the rules which we as dispute board members should be very careful about, okay? It is not a rule which grants unlimited powers to the dispute board to decide upon financing charges. Financing charges are interest, for example, okay? It's not an open book for everything, okay? That should be very well understood. And it is clear, I mean, the rule is clear when it says that it should be applied in line with the contract, okay? You're not a fighter, you're not a justice avenger, okay? You're applying the contract, and again, this is very important. So, in my view, the dispute board should analyze carefully what the contract say, and if applicable, the local law says about the issues in dispute and how the parties comply not with their obligations, when, etc. Carefully, very, very carefully, okay? And then, and only then, should financing charges be decided upon. And as we all know, financing charges, mean money. So again, for the third time, we should be very careful when applying this important rule, which should be there and empowers properly the dispute boards to decide upon this issue. That's it. I don't know your views on this, Giovanni.
Jaime, being the good lawyer you are, you really nailed it well. I couldn't agree with you more over every word you said. We must understand that obviously this is a very important responsibility. You have to decide on money to be paid from one party to another. The letter or contract needs to be observed with absolute knowledge of contract law, and this is obviously why a dispute board members should be extremely experienced in contract matters, starting from contract law, how it works, because financing charges are a damage, and for a damage to be allowed as compensation, there has to be a breach. So it's not just a question that a contractor has not been paid an amount and automatically is entitled under subclause 14.8 of the FIDIC Red Book contract to financing charges. There is much more to that because it has to be a genuine breach that allows the power of the dispute board to decide that financing charges are due from a specific date and calculate the amount, and then obviously extend that relief until a payment is made. So although it's so simply put, but this is one of those aspects that the dispute boards should be really experienced in contract law and construction law. And this is why I am one of those promoters that the 3-member boards should have always a very senior construction lawyer, either as the chairman or as a DRB member, because we deal with matters of money and we need to be absolutely sure. And that's where a construction lawyer will be a major added value. Thanks, Ilma.
Very good considerations. So, while analyzing Rule HG, which states that the DAB has the power to decide upon any provisional relief, such as interim or conservatory measures, do you believe that in case where an interim or conservatory measure requested by a party would be beneficial to the resolution of a dispute, the DAB can actually make such decisions in order to provide the affected party with the optimal outcome, as indeed arbitrators are empowered to do so in arbitration? It's too long question. Please, Giovanni.
Thanks, Ilma. This is, I think, the most complex of the rules that the draftsman of FIDIC has included in the procedural rules. This should be really used with extreme care because it can create obviously a disadvantage to one party, and that cannot be done. A proper analysis of this rule allows the DAB that power if a party requests an interim or conservative measure to consider it. But it's that consideration that has to be taken under serious analysis, because you cannot just have a request for an interim measure unless it's part of an underlying dispute that has been already referred to the dispute board, because that power is not bestowed on the dispute board. And I give you an example. Let's say that there is an extension of time claim that has been rejected. And then obviously there is an employer request for delay damages because the time for completion has expired and he rejected the entitlement to extension of time. And the contractor refers to the dispute that he has an entitlement to that extension of time and to a monetary compensation thereof. So that is the underlying dispute. Now, in the event that the employer notifies the contractor that he's going to apply a deduction to his next interim payment certificate, or is going to send a request for delay damages to the contractor, and if he doesn't pay within so many days, he will call on the performance guarantee. Now, in that particular case, if a request has been made as part of the statement of case by the contractor, or immediately after the statement of case within the 84 days, this is a valid ground for the dispute board to issue an interim decision to maintain the status quo until he gives his decision. It's only a temporary relief, because if he arrives at day 84 and he decides against the contractor, then obviously the employer after day 84 will have the entitlement to charge the damages and call the guarantees. But until the DAB has decided, he will not have that right to do it under the contract. If the employer goes against the DAB interim decision for a conservative measure, then obviously the DAB will infer accordingly, and the employer will have to take responsibility for a breach of contract, because that's what amounts to. But this is just a couple of examples that shows how complicated it is. I'm sure that Jaime can write a book about this. Being a construction lawyer, he deals with these matters every day. Jaime.
Thank you. You know, and your example, you know, it's very, very, very valid. I have seen dispute board members who are, you know, very willing to say, yes, I grant the measure, an interim measure, while some others think that even though the contractor, following your example, you know, is requesting an extension of time, and you will have to decide upon, they think that you know, that the employer is always entitled to deduct, you know, money from the next certification statement. So, you know, the views, you know, are on the opposite side of the table. So maybe, Giovanni, why not we should write together an article on this issue, because it's very important to have common ground for this important issue. That said, Giovanni, I think that these types of measures should be applied under an approach different than a traditional arbitration approach. Okay, I have seen that also. Okay, our fellow members, you know, apply an arbitration approach for, you know, an arbitration test for granting or not this type of measure. However, the power is in there undeniably, and we should apply provisional relief, taking full regard of all contractual circumstances. And yes, in some cases, this optimal outcome may apply, and in some cases not, depending on the specificities of the case and the circumstances. Again, this power is very ample, and again, should be exercised with care, doing all necessary tests to decide upon this type of measure. And for example, we should discuss, is it reasonable to grant the measure? In the arbitration world, you don't see that very often. Is the project, Giovanni, or the counterparty affected by the measure? That's very important, okay? You need cash flow to complete your project. Could any adverse effect on the measure be rectified in the future? How is that reasonable, etc.? Okay, so, you know, this is, as you mentioned, you know, a very complex issue, and let's see if, why not we may prepare a paper on this.
Indeed. Jaime, on the other side, you know, obviously, because it's so complicated and obviously it requires a construction law background, But it doesn't mean that if you are a sole member DAB and you are a quantity surveyor or an engineer, you will not grant because you don't understand, what is immediate danger, what could be, the infringement of a legitimate commercial right. It needs preparations, and those who embark these days on becoming a dispute board member, they should seek proper construction law training in understanding this, because this is just not a matter of doing a FIDIC seminar or a FIDIC training. You will not be taught this by any of the courses that you will take. This comes from experience, it comes from construction law. Because it needs to be used with care. I'll give you another example. A matter has been referred to the dispute board, and that is due to the fact that the engineer, wrongfully, because under the FIDIC 1999, it is not specified at the time for the engineer to issue a determination. He has sat on the fence because he was not sure of himself or herself, and he didn't give a determination. Now, the lack of determination, if has been requested and is due, can give rise to the crystallization of a dispute, and you can go to the dispute board. Once the dispute board has taken on the case, and he has to decide within 84 days. If the engineer comes at any time and he is saying that we should stop, extended the time for the DBD's decision because the engineer is about to give the determination, and the contractor says, but this is not right. I mean, what are we doing? We disagree with that. I'm asking for an interim measure. We have the power under this to instruct the employer and the engineer not to pursue the determination, and if it does, the contractor, the DAB will infer accordingly. And this will show the party that wants to push, he will think 10 times before he will allow, especially an employer. He will tell these engineers, stop there, because this can go against us. You know what I mean? If there is no agreement. So this is one of the other reasons. Look, this is a powerful empowerment, which needs to be, in the words of Jaime, used with extreme carefulness. You got to really understand how to use this, because you can damage other way, either because you're afraid to use it and you will not give an interim measure, or you are too eager to give and you can make a serious problem that after that can jeopardize the DB decision, and it's an issue after that.
Ilma, may I say some final words for these? Giovanni,
please.
Please feel free to.
These are tools. These are tools. And with a tool, you can build a house, or you can harm yourself and harm the project and the parties. That the concept of the tool and how to properly use it is very important.
Yes.
Excellent analogy.
Okay. Very good explanation, guys. So the next one is the last question. When examining Rule 8, letter 8, which states that the DAB has the power to open up, review, and revise any certificate, decision, determination, instruction, opinion, or evaluation of the engineer relevant to the dispute, do you accept that the DAB has the authority to examine and revise any offset documents which would be related to a dispute, to the extent that the DAB shall have the power to review the engineer's judgments and make adjustments to it as the DAB deems necessary? Please, Jaime.
Okay.
And then Giovanni.
I will start, Giovanni, if I may.
Please.
Thank you.
Please.
The question, it says, do you accept? In this case, yes, I accept that the court has this authority. I think that this power, let's remember our first part of this conversation. You know, these are powers that both parties grant to the dispute boards, and this power, I think, is well established, clearly established. And let me say something. In my view, this power is necessary for the correct functioning of the dispute board. I cannot honestly, Giovanni, Ilma, imagine that a dispute board who is unable to review certificates, decisions, determinations, instructions, or valuations of the engineer. That scenario, which is denied, would only bring problems to the dispute board. However, it is of the utmost importance to carefully exercise this power. We should always take due regard of all contractual circumstances, including the entitlement to the right claim, notices given in a timely manner. Let's remember that if we have a FDBF contract, or in general construction contracts, many time bars may apply, except in jurisdictions such as Brazil, Ilma, or Peru, in which this is a whole debate. Also, you know, substantive right, or if the engineer made or not a correct interpretation of the contract, etc. So, in short, yes, I do accept that that the dispute board has this authority. But again, and this is, I think, the regular type of answer that we were sharing during this conversation that I'm really enjoying. We should be very careful with applying this power, again, because it's a power granted by the parties. And we should be very, very careful and respectful with the parties with applying this power. What are your views on this, there, Giovanni?
I couldn't agree with you more, Jaime. You know, these powers cannot be abused. This specific one, it is my interpretation that the FDBF draftsman had the view that obviously the dispute board may help the parties and the project to proceed. I mean, help cash flow, for instance, a payment certificate that is applied a major deduction that can cause serious cash flow problems to a medium-sized construction company. You know, it could be rectified under a decision of the DAB by calculating what the dispute board believes that is the right amount, and then instruct through the decision to make payment within so many days, and then obviously an employer that is facing, you know, a decision that shows that the engineer has had the wrong interpretation of the contract or any part of it, and then obviously he has to pay because it may create damages, and he may harm the employer that is not going to get his job done on time. So this has a practical use, but it cannot be abused, and it must be always used by very experienced dispute board members, because if there has been a determination of the engineer in whichever time, but the parties have not issued a notice of dissatisfaction to the DAB decision for a very long period of time, and then as part of a dispute, one of the parties out of the blue, it challenges the determination of the engineer. That challenge could be, you know, useless, because the determination of the engineer in certain circumstances can become finally binding if has not been challenged. And I mean, there are arbitrations, awards that have dealt with this. You know, it needs to be, for instance, a party challenges, but the other party doesn't, and then he wishes under a dispute to also have a relief from the party that he did not challenge. Well, he has lost that right because he did not challenge it; he accepted. So this is, you know, another power that needs to be dealt with by professional dispute board members and understand how, you know, proper interpretation on the contract and the timing that certain, you know, possible material breach have taken place have been dealt with. So again, cannot be abused. It is a good tool to get things moving, but it needs to be used with care. Thank you.
Very good. So We are ending our webinar, and Giovanni and Jaime, congratulations for your brilliant explanations. Certainly, both of you provided very important explanations about the theme that we've discussed here today. I'd like to thank everyone who spent their time to be here with us. And I'd like to know if you have final considerations, Giovanni and Jaime. And thank you for your attention.
Well, just thank you, Ilma, for moderating the panel so well. And many thanks to Anne Russo, the executive director of the DRBF, for having woken up at 4 o'clock in the morning and support us this link. That shows her dedication to the cause and her professionalism. And I want to thank my dear friend Jaime, that we just been together in Switzerland last year, and we enjoyed a bit of time together. And I hope to see you in May in Brazil, Ilma, when we will come for the international DRBF conference, at which Region 4 and this marvelous president will be empowered with the regions and the presidency. And thank you everybody for listening. And if there are questions, please just send them to the organizers, and I'm sure that we both will be very happy to answer them. Thank you.
Thank you. Jaime, please.
I would like to echo what Giovanni has just said. Thank you very much to you all. I really enjoy this conversation. I think that these ideas will be useful to the attendees and others who will watch this recorded session. And it has been a pleasure, really. I'm sure that I will be enjoying the pleasure of your company in May in Sao Paulo. Thanks very much.
Thank you, Giovanni. Thank you, Jaime. Thank you, Anne. Have a nice day.
You too. Bye.
Thank you.
Bye.
Thank you. Bye.